Hello and welcome to Unlocking the Value of Insurance, equipping corporate policyholders in the construction industry with essential tools and knowledge. This is session 1, Insurance Coverage Fundamentals, of a 3-part series. The second session will be on April 28th and the third will be on May 22nd. Registration for those sessions will be forthcoming. While it is a series, it is perfectly fine to drop in on any 1 or 2 of the sessions. These sessions build off of each other. So the first today will be coverage fundamentals. Session 2 will be negotiating with insurers and claim management. And session 3 will be the thornier issues of construction and insurance. But each one has a lot of great topics as standalone webinars. If you have any questions, please type them in the chat box and we will address them at the end in the interest of time. We have a lot to get through, so I'm going to kick it off with some brief introductions. My name is Mikaela Whitman. I'm a partner in the insurance recovery group at McGuireWoods, and I'm based mainly in LA, but also spend a fair amount of time in the New York office.
Hi, good morning. My name is Michael Gehrt. I'm a partner in the insurance recovery group as well, and I'm based in the Los Angeles office.
Hey everyone, my name is Thatch. I'm a partner in McGuireWoods construction practice, and I am based in the Washington, D.C. office.
Hello everybody, I'm Mike Dingman. I'm also in the construction practice group at McGuireWoods, and I head up that group, and I'm based in the Tyson's office.
Okay, so a little bit more about who we are and what we do. Mike and I do insurance coverage, as we just mentioned. We're exclusive policyholder attorneys, so we never represent the insurance company. We handle all stages of insurance disputes in jurisdictions nationwide. So that means we will be involved on the front end, advising policyholders and policy placements and conducting policy reviews. We'll help with notice of a claim and determining whether there is coverage. And then if an insurance company denies coverage or issues a reservation of rights letter, we'll get involved in the actual dispute, either in ADR or through litigation. I'm gonna kick it over to Mike and Chris.
Thanks. So our construction group has about 25 or 30 attorneys who are predominantly focused in the construction industry. And a couple of things that make us unique is we represent all the participants in a construction project: owners, developers, contractors, subcontractors, engineers. So it gives us a very unique perspective of the viewpoints of the participants in any project that you can think of. And we are involved in just about any project you can imagine, from energy to multifamily to mixed use. And the other thing I think is unique about our practice is we are heavily involved in the upfront contract preparation and negotiation. We counsel our clients during projects. And then if it comes to a dispute, we have really good experience in arbitration and in federal and state court in representing clients on any number of different types of construction disputes. So we can really take your project from beginning to end.
And I'll just add briefly, because today is insurance fundamentals, you probably won't hear a lot from Mike and I. We'll jump in when necessary and when it's useful. But I just wanted to give that disclaimer. You will hear a lot more from us almost certainly during sessions 2 and 3. But nevertheless, I mean, this is a very, for our construction practice and for Mike and I and for our clients, these insurance fundamentals are very important. And we do our best to work hand in glove with the insurance recovery folks on our projects. And this is also, as I'm sure all of you know, a very relevant topic now, just in general. And I'll give you a few stats from the industry. But in 2003, 54% of U.S. construction companies reported expanding their insurance coverage to address risks, including natural disasters, obviously a recent issue, and cyber threats. And the average construction insurance premium in the U.S. rose by 8.5% in 2003, driven by inflation and other factors, will almost certainly continue to rise. And maybe most interestingly, the construction insurance market is projected to grow by 6.5% annually year on year going forward, reaching an estimated $18.6 billion by 2025. So these are issues that are absolutely relevant, not only to our practices, but almost certainly to your businesses.
Thanks, Chris. And that's a great segue into the next slide, which is the goals of the program, because insurance is so fundamental in the insurance construction industry. Unlike a lot of programs on insurance, this is not designed to drone on about case law and just, precedent setting what's going on right now. This is designed to offer practical advice about how to deal with insurance issues in an insurance dispute when they arise. We want you to think of insurance as an asset, not an annoyance. You pay a lot of premiums for those policies, and you should get the benefit of those policies. We want you to have the tools and knowledge to recognize and handle insurance disputes when they come in the door. We want you to know how to set up an insurance claim on the front end so that you can limit the insurer's defenses on the back end. We want you to consider all sources of coverage and always think there may be coverage for that claim or loss. And this is really important because a lot of people think right away, I don't have coverage for that. I'm not even going to look at my insurance policies. There's nothing there. But if you kind of flip your mindset and think I might have insurance coverage for that, then you're looking at all your policies, or looking at all your sources of coverage. And that's going to maximize your potential recovery, which is goal number 5 of the program. And also know when to ask for help. When you need to ask someone, an insurance recovery attorney, you know to ask a construction attorney, know when there's issues arise that you can't deal with. Honestly, if you take just 1 or 2 of these mindsets from the program, I feel like you've gotten a lot out of the program, because these are basics that will help you maximize what you can get under insurance policy. So today, as Chris mentioned, this is more of the nuts and bolts of the series. What is insurance? Who are the players? The anatomy of an insurance policy, the insured's duties and conditions to coverage, the insurer's duties, and the rules of policy construction and policyholder maxims. And we're going to talk about constructions issues as they arise in these topics. These might seem really fundamental, but these are the kind of building blocks to deal with the thornier issues that arise later down on the line. So if you understand these things and how to apply these principles, it's going to help you with the more difficult issues and getting the most from insurance companies. Okay, what is insurance and who are the players? I love this slide because this is how most people think about insurance. Sometimes it feels as if the only thing that purchasing insurance actually ensures is that one will eventually have an unpleasant dispute with the insurer over payment on a claim. Most people hate insurers. I, for one, hate dealing with, even as an insurance attorney, I hate dealing with my health insurance, like worst thing in the world, because it feels like all I'm going to do is fight with them. So what is insurance? Insurance is a risk transfer mechanism. The business of insurance is to keep money as long as possible. It is not to pay claims. The longer an insurance company can keep that money, the longer they have to use that money to invest in other things. They can make more money off of that money. So insurance companies are not your friends. They're not there just to help you. They're there to make money off of your claims. Insurance policies are contracts, and they're subject to contract interpretation principles. That means contra preferentum, those kinds of things, those kinds of principles that you would use in contract interpretation can also be used when you're dealing with an insurance policy. Insurance law is regulated by state law, so it's going to differ greatly between each state. It'll also vary greatly between country. I'm dealing with a lot of cases in Australia right now. The law in Australia is very different than the law in the US, especially when it comes to construction projects and insurance. Certificates of coverage, declaration pages, summaries of coverage, none of these provides coverage. We're going to talk about certificates of insurance in a little bit here in greater detail, but these are often pieces of the policy that are given to parties on a construction contract. And then people think, oh, I know what my coverage is, I have it. That's not true. It's not the policy, and it will not provide you all the details of coverage. Insurance is designed to cover fortuitous events and specific risks. People always say, well, what do you mean fortuitous events? I mean things that you don't know are going to happen. The contractual liability exclusion, for instance, people say, why does that apply? Why can't I contract for what I agreed to in a contract? And that goes to this principle is you can't contract to owe someone money and then say I want insurance for it. We're going to talk about the contractual liability exclusion in session 3, I believe, which often arises in insurance construction disputes. And lastly, insurance typically covers claims against the insured, not claims by the insured. So if I make a claim against someone, I'm not going to get typically insurance for that. It's if someone files a lawsuit against me or makes a claim against me, as what I'm getting insurance for. Okay, occurrence versus claims made policies. An occurrence policy covers the insured's liabilities for injuries or damages that happen during the policy period, regardless of when the claim or suit is asserted against the insured. So your standard occurrence policy that everyone probably knows the most is your comprehensive general liability policy or your CGL policy. This is very different than a claims made policy, which applies to claims made against the insured during the policy period. Coverage does not depend on when the actual act occurs. It depends on when the claim is actually made against you. So examples of this would be your professional liability policy, your directors and officers policy, your builder's risk policy. And then you have kind of a step beyond just a claims made policy. You have a claims made and reported policy, which says you have to have the claim made against you and you have to actually report it to your insurance company to trigger coverage. It's really important just at a base level to understand if you're dealing with an occurrence policy or a claims made policy, because especially in a claims made policy, notice is so important because it triggers the policy. So you don't want to miss that. Okay, who are the main players? You have the policyholder or the insured. Those two terms will often be used interchangeably. Then you have the broker, the different types of brokers, and we're going to go into brokers in detail, but they're the ones that are helping you place the policy. And then you have the insurance company, your captives, and your reinsurers. This is just a broad overview of the main players here. We're going to talk about these in different depths going forward, but just to have a big picture of who they are is helpful. And I'm going to turn it over to Mike to talk about a broker.
Thank you. So starting with a broker, at a broad level, what is an insurance broker? They're essentially the middleman between the insured and the insurer. And depending on their role, they could move into one bucket or the other. But as a general rule, they're there to solicit insurance business from the public and place insurance on behalf of the insurer. This isn't a broker liability presentation, but we'll touch on a few of those issues. The primary duty for a broker is to use reasonable care, diligence, and judgment in procuring the insurance requested by an insured. That's fairly loaded. Reasonable care is not a particularly high standard, especially speaking as an attorney, I wish the standard were a little bit higher on a broker. And as well, it's only to procure the insurance requested by an insured. And we'll get into what kind of some of those limitations are because it surprises insureds often when they learn how little the obligation or of the duty of reasonable care for a broker actually is. So I mentioned that they can serve kind of different roles. People generically refer to a broker, but it's important to know kind of which side of the fence they're working for. So an agent, and people use these terms somewhat interchangeably at times, so it's important to kind of understand the exact relationship that's being defined. But when we refer to an agent, generally that means they're acting on behalf of the insurance carrier, the insurer. And in that instance, their actions are binding on the carrier. So if they make representations regarding what is covered and what is not covered, that's binding. Juxtapose that with a broker. Broker generally, again, we're talking in generalities, generally acts on behalf of the insured. That said, they can have dual capacity. They can sometimes act on both sides, in which case their statements can therefore be binding. But if they're only acting on behalf of the insured, their actions generally do not bind the carrier. And that's important because oftentimes an insured will say, look, my broker told me that we were fine, that we had what we needed. Well, that may create liability in the broker. Well, we could touch on that, but it's not binding on the insurance company. They're only bound by the terms of the contract. So we talked about some general rules on agents and brokers. These are some of the things that will surprise folks. As a general matter, and I'll get to the exceptions to that, but as a general matter, agents and brokers have no duty to recommend appropriate coverages. I'll often hear that, look, my broker didn't tell me I needed this. That doesn't necessarily create a broker liability claim. They have no duty to recommend the appropriate amount of coverage. They have no duty to notify the insured of cancellation or of financial condition or of insolvency. As a general rule, that's true. They're simply there to place the insurance that was requested by the insured. However, And I would caution everybody to review their agreements with their brokers, because a lot of those agreements can be modified. And I've advised on a number of them in terms of expanding the role and the obligations of the broker to include a number of these things: recommending appropriate coverages, recommending appropriate amount of coverage. A lot of clients run into significant issues on coinsurance. They don't understand how coinsurance works, and they would like to have the broker advise on what the appropriate level of the coverage is, so they don't have to get hit with a huge coinsurance penalty on the back end when there's a claim. So those things can be negotiated as part of a services agreement, and a lot of high-end brokers typically will include a number of these types of obligations as part of their services agreement. But it's important to include them on the front end so that you're protected on the back end. Okay, so oftentimes we speak pejoratively about brokers, but they're both positives and negatives, is what I would say. They can absolutely be a helpful advocate, particularly if they have strong relationships with the insurance companies. I've had a number of claims where we've worked the business angle on the back end, and the broker's been integral in that negotiation, and they've pushed to get a deal done when the parties were close but had not reached a resolution. And so they can be really helpful on the business side. There's a significant privilege concern that we want to address, and I'll get into that in the subsequent slide. But always one that we want to caution folks on. The broker can also provide visibility to how insurers have handled similar claims. They have much more visibility than, for example, we do as coverage counsel in terms of claim volume. And they can say, look, you regularly pay these claims out, or they regularly pay these claims out once you establish X, Y, and Z. So they have that institutional knowledge that's very helpful. That said, they're not always well-versed in the case law, and they are rarely inclined to advance nuanced coverage arguments. And that's because, it goes to the first bullet, they know how similar claims are handled. They know the generic insurance industry response to a variety of these claims. They don't necessarily push the envelope on those claims. And I think that's where coverage counsel comes in. The broker can use the business relationship, coverage counsel can push the legal and contractual language. In general, brokers tend to be more successful at the early stages of a dispute. Once insurance coverage litigation or arbitrations are involved, typically the broker takes more of a backseat to those discussions and have less influence in how those can be resolved. And lastly, we always recommend to consider if coverage counsel should be taking lead rather than the broker. That's a timing issue, and it's not one size fits all. But it's always something we want to consider. We'll get into kind of the role of coverage counsel in a moment.
Yeah, Mike, let me just comment on that last piece, because I've worked with brokers, and I agree completely. They have good access to the insurers and knowledge of how they handle claims. But in my experience with them, they typically have a fairly limited understanding of the underlying contract, project, and claim. And they also tend to not have a good understanding of where the claim may be going and the impact of whatever the event may be. And so I think it's a good strategy to have I wouldn't call us defense counsel yet, but your construction counsel involved early on. And in my experience, we've worked very well with the brokers. They appreciate the knowledge that we bring to the table. We appreciate the knowledge that they have with the insurer we're dealing with. But I think just going with your broker is a bit risky, because they often simply do not really understand the ramifications of your claim and what your contract says. And that's where we can come in and sort of educate the broker, and then we can work together to get the best result we can for you.
Yeah, I think that's a great point. The broker's always, and I sympathize a little bit, the broker's always in kind of a difficult situation. Their business relationships are with the insurance companies primarily. I mean, they obviously value the relationship they have with their insured. But they're not inclined necessarily to rock the boat sometimes. And so I think it's always good to kind of have both sides involved, both construction counsel so that they can understand the claim, and then coverage counsel so they can understand the coverage. And as part of those interactions, one of the issues that always comes up with brokers is privilege, because At least I'll speak for my clients. They always, view their broker as part of the tent, part of their team. And that's fair because they've been working with them for years and et cetera. But not all communications with a broker are privileged. There isn't a hard and fast rule, but generally, the question of whether or not the communication of the broker is privileged depends on the facts, and it typically hinges on whether the policyholder retained the broker, at least in part, not exclusively, but at least in part, as its agent to help with claim adjustment or the formulation of litigation or settlement strategy. So what does that mean? I mentioned broker agreements before in terms of expanding the scope and the obligation that they have in advising the availability of coverage or the scope of coverage, the amount of coverage. Typically, you can also contract for what we would call claim adjustment or claim support services. In that role, the communications generally, the case law has generally been has held that those communications are privileged because they're essentially serving kind of a quasi advocacy role. However, if they're simply communications with the client that is not an attorney and not at the behest of an attorney and the broker, keeping those privileges is much more difficult, particularly when you're prior to any coverage litigation or alternative dispute resolution. So we always caution folks to really think about, does the broker need to be on this communication? And if this communication is directed by counsel, to include counsel in those communications to make it clear that this is in the furtherance of litigation or settlement strategy as opposed to in their purely as their broker role. Okay, so some best practices, and we'll try to keep moving quickly here, but we touched on a lot of these. Enter into a formal consulting agreement before sharing communications. That helps with privilege, I just mentioned. Think before you send. Does the broker absolutely need to be on the communication, or are you just continuing a long stream of email correspondence that had them to start, but they don't necessarily need to be on them subsequently? Keep documentation, always a good recommendation. We talk about the duty of a broker. It's helpful if the broker is retained for expertise in a particular area. That expands their obligation because they are now holding themselves out as an expert, for example, in construction law or in construction insurance. If they're held out as an expertise in that area, then they have a heightened burden or a heightened standard that they need to meet. And finally, communications, in order to maintain privilege, communications must be for the rendition of legal services for the policyholder. Again, we always want to highlight that privilege issue.
One thing I wanted to mention, Mike, on the privilege issue, a lot of clients think that if they include in-house counsel on some of these emails, that they're privileged. And that may not be true. I won't go into the examination of whether it's privileged or not, but if you're talking about what happened on the project and why you think you have a claim, just including in-house counsel typically is not going to protect that communication from being disclosed if there's a dispute later on. And so you do need to think about who you're including on your communications and what you were saying, because if you end up in a dispute, those are the types of emails in particular that the other side's going to dig for to push back on your claim.
Yeah, absolutely. There isn't you don't get just blanket protection by CCing somebody. That's why we mentioned it has to be in the furtherance of litigation strategy or settlement strategy, what have you. So that gets us to kind of one of the other players, which was coverage counsel. And I'll try not to make this as self-serving as possible, but one of the key considerations is when and whether to engage coverage counsel. We always recommend as early as possible, just because the role might not be significant. It might be a few hours here or there, but we can obviously, if we're involved early on, can head off some serious issues down the road. Typically, when we start as coverage counsel, we're kind of a ghostwriter. We're kind of in the background. We don't make our appearance known to the insurance company until much later. But we try to advise on coverage limitations, on what to say, what not to say in terms of proof of loss. So we can usually shape a dispute more effectively if we're involved early on. One of the major considerations oftentimes is whether or not an insurer is going to jump us. So there's jurisdictional considerations that coverage counsel can assist with. Do we want to be in a particular jurisdiction as opposed to another? Because as Mikaela mentioned earlier, state law varies. And if there's an argument for one jurisdiction that has, a beneficial notice prejudice rule as opposed to another jurisdiction, there may be a reason to initiate litigation in advance of the insurers jumping you and trying to forum shop and get a better location for their dispute. We can also assist in determining whether, when, and where to initiate coverage litigation. I mentioned that in terms of jurisdiction, or more in terms of timing. There's contractual limitations periods, statute of limitations. All of those need to be taken into consideration in determining whether or not coverage litigation is going to be necessary, as well as whether or not it makes economic sense. There's cost-benefit analysis that is done in terms of coverage litigation, arbitration, or do we go try to resolve this through mediation? All of those coverage counsel can assist with. We mentioned too, in terms of brokers, coverage counsel can perform an independent review of the coverage. And typically what we'll do, the value we add is we see coverage that is, outside of kind of the standard practice, which where a broker would look at. And so we can see additional sources of coverage or perhaps ways around exclusions that sound that they may or may not apply, but we can obviously sometimes find ways around those. And then finally, and I think this should not be understated, is that we can work in conjunction with underlying defense counsel to maximize coverage and minimize coverage issues and potential defenses to coverage. And the most often time this comes up, for me at least, is even in the context of underlying mediations, we can work with defense counsel to talk about where the exposures are, what exposures to emphasize, what exposures not to emphasize vis-a-vis the coverage, because oftentimes defense counsel is not necessarily focused on. They're focused on the underlying defense, rightfully so. But coverage counsel can work hand in hand with defense counsel to make sure that we are focusing on the risks that create exposure for the insurance company and therefore can increase settlement possibility. And also, talk about and focus on the risks of the case. Defense counsel will often speak in terms of we can defeat X, Y, and Z, and they're aggressive on their defenses, but we have to wear kind of a different hat when we're trying to get the insurance company to pay, and coverage counsel can assist with that as well.
One thing I just add, construction counsel can help with the affirmative claims as well. For example, who do we think could be responsible for the issue or the event? And that may unlock insurance coverage from different participants in the project. And so again, being involved in your project, we have a pretty good understanding of who's doing what. And by the time we get to a claim, we can help identify who are the potential pockets of recovery in their insurance companies and how can we draw them into the claim. And so that's something we do on a regular basis as well.
Yeah, that's a great point, because it can go beyond even other parties available insurance. There could be indemnity obligations, and so it's really the whole milieu of who needs to be paying for what. And I think that's a great point, because there's multiple sources of coverage and of potential liability. And so getting back to kind of our insurance fundamentals and getting away from kind of the players. We talked about brokers and we talked about coverage counsel. So now let's get back to insurance. We talked about occurrence versus claims made. There's also, just in terms of terminology, first party versus third party insurance. I'll do this very quickly, but first party insurance essentially covers loss or damage sustained by the insured, sometimes called casualty insurance. But the typical examples that you'll find is, property, business interruption coverage is first party. Crime and fidelity coverage, that's first party insurance, falls within the first party umbrella. Homeowners coverage, likewise, falls within the first party umbrella. First party insurance contrasted that with third party insurance, which covers the insured for claims or suits by third parties, alleging that they suffered injury caused by the insured or for which the insured is otherwise responsible. So the easiest, this is essentially coverage for lawsuits or claims against the insured. The typical examples of that include, we've already mentioned, CGL coverage, commercial general liability coverage, directors and officers liability coverage, errors and omissions liability coverage, also sometimes referred to as professional liability policy coverage, Also, employment practices liability coverage. All of those would be, your standard suite of third-party insurance policies. Some policies, again, just going over terminology, are referred to as package policies. What that generally means is that they're combining first-party and third-party concepts. So they can have a crime and fidelity coverage and include some errors and omissions coverage as part of an overall package. Cyber coverage oftentimes is a package policy because there's first-party elements to it and third-party elements to it. And so we just wanted to kind of orient everybody in terms of terminology. Mikaela mentioned we want to focus on one of the takeaways of this presentation is looking at insurance as an asset. So we want to understand the different applicable coverages and different assets we may have that are responsive to a claim. These include property business interruption coverages, builder's risk coverage, CGL coverage we mentioned, D&O, E&O, employment practices. They also include some very specific types of policies that are more specific to the construction industry. We'd like to just touch on those here. We're going to be addressing a number of those other coverages in subsequent portions of this series. So I'll leave those there for now. But we wanted to touch on project-specific liability policies because they're unique to the construction industry. These are policies that are typically for a single project. They can be tailored to for certain parties and or certain risks, and can often be contractually required. In addition to PSLPs, there's also RAP policies, a commonly used term. These provide comprehensive liability coverage on a project to all parties. So that would include general contractors, subcontractors, the project owner. Terms that are thrown around, owner-controlled insurance programs versus contractor-controlled insurance programs. They're simply just the difference is, as the name suggests, which is who purchases it, the owner or the general contractor. These RAP policies generally provide CGL coverage, but they can often include additional coverages, including umbrella coverage, which will be touched on in a subsequent slide, workers' compensation insurance, and can even add on builder's risk or professional liability coverage. So it's really dependent and open to negotiation. And finally, the contractor's protective professional indemnity policy, offered by Zurich and Catlin. This provides professional liability coverage to the contractor. It can also provide pollution liability coverage. So we just wanted to highlight these specific coverages because they're unique to the construction industry.
Hey, Mike, just a couple of quick comments. I would say that the majority of projects I've been doing in the last 5 years almost all have an OSIP or a CSIP insurance program. And my sense is there's not a lot of examination of that program. You'll get an 80-page document from Marsh or whoever. It looks good. They're a good player in the industry. But you do have to be aware of gaps in that coverage. Some subcontractors may not qualify. Off-site work may not qualify. So I think it's important to have someone like Mike or Mikaela take a look at that policy, because I think a lot of folks just assume Marsh put it together, and I'm not saying anything negative about Marsh, and so everything must be covered. But you don't want to have a gap in your coverage because you think a certain sub is under an OSIP or a CSIP and they're not. And then they cause a problem on your project, and you're not able to call on insurance to deal with that. So that's just an observation for me, is that I see these all the time. They're very long documents, and maybe some folks are diligent enough to look at them, but it's worth having somebody, again, like Mike or Mikaela, make sure there's no gap in the coverage.
Yeah, and I actually, it's funny that you mentioned that, because I just had a client last week on a builder's risk policy. It was the developer. There was an expansion on the builder's risk policy that included coverage for certain soft costs, certain delay costs, but it was only extended to the named insured, which was the contractor. It wasn't extended to the developer, which would presumably be an oversight because they had substantial insurable interest in delay. But they just simply, that extension of coverage was limited to only the named insured. And so they were, stuck in a bit of a pickle. So again, just reiterating that point.
Okay, as Mike mentioned, excess insurance, we're going to talk about tiered insurance programs. So businesses in the construction industry address how much coverage they have, usually through tiered insurance programs. And excess and umbrella insurance are two terms that are often lumped together, but they're actually very different things. So excess insurance provides coverage upon exhaustion of underlying primary limits. So it increases the amount of coverage. It does not broaden coverage. It can be a standalone policy or it can be follow form. Follow form means that it would follow the exact terms of the underlying policy. Standalone means it might change the terms of the underlying policy. So it's important to read the excess policy as well, but it wouldn't provide new coverage or extra coverage. An umbrella policy, however, provides excess coverage and insures risks that the underlying policy does not. It's a gap filler in coverage. There's a little very basic drawing there that kind of shows the difference between the two. And often you'll have a primary and excess and then an umbrella policy, or you can also just have a primary and an umbrella policy, depending on the structure of the program. Okay, deductibles and self-insured retentions. Also kind of like excess and umbrella policies, these are two terms that are used interchangeably, but actually have different meanings. So a deductible covers the loss and then is reimbursed by the insured. So the insured covers in a deductible, the insured covers the loss and then it's reimbursed by the insurance company. Or the insurer reduces the amount it would pay that it would otherwise have to pay. So for instance, I think the best way to see this is an example. $1 million liability policy with a $50,000 deductible is essentially $950,000 in potential limits. The policyholder paid that deductible and then it had less coverage above it. An SIR, unlike a deductible, is a specific amount of loss that must be incurred by on behalf of the insured before the coverage obligation is triggered. So for example, $1 million liability policy with a $50,000 SIR is $1 million in potential limits, but only after the insured incurs the $50,000. So under an SIR, under the same policy, you'd have $1 million in limits, but under a deductible, you'd only have $950,000 in limits. So it's important to know whether you have a deductible or an SIR. And this is especially true in construction cases, and because deductibles and SIRs are rising right now. There's been a trend to get higher and higher. So you really want to know how that applies, because depending on how big that deductible or SIR is, it could greatly affect how much coverage you have, depending if it's a deductible or an SIR. Okay, sources of coverage. We touched upon this at the beginning, but you should consider all potentially applicable insurance policies. Mike went through the list that we're going to talk about each one in detail of policies later in the series. But just because one of those policy applies, doesn't mean another one can apply as well. So several of those policies could provide coverage for one claim. You want to look at primary and excess umbrella policies, which we just talked about. You want to look at different lines of coverage. You want to look at historical policies. This is true especially on your occurrence-based policies, your CGL policies. For example, the classic case is asbestos. If you had a company that's been operating for 30 years and someone was exposed to asbestos in the 1970s and they found out about the asbestos exposure in the 1980s or present day and made the claim against you, it would be those policies back in the 1970s that apply, those occurrence-based policies. So you want to know what your historical policies are and what coverage they provide. Named insured and additional insured status. Additional insured status is extremely important in the construction industry. You want to know what policies you're named on as additional insured, and you want those policies in full. You also want to consider all contract and indemnity agreements. If you don't have insurance, you might still have a source of money for loss under an indemnity agreement. And we're going to talk about indemnity agreements at length in session 3, but this is really important in construction projects.
Yeah, and I'll just jump in here quickly, Mikaela, and say that's a great point. And I think another plug for having both potentially coverage counsel and construction counsel involved fairly early in a project like this. You want to be, if you can, creative and strategic about determining what that indemnity agreement covers and how you can use it in conjunction with the coverage that you're receiving through your insurance. And so oftentimes the folks who are putting together the indemnity agreements, the folks who are in charge of determining the insurance coverage, if they aren't talking, then you don't have the ability and the advantage of working together to craft a provision for indemnity that works well with whatever coverage you've established through your insurance